estate license exams for dummies. Part 2. So you want to sell real estate, the job and basic laws. Chapter 5. Knowing the fair housing laws for selling real estate. In this chapter, finding out the basics of fair housing laws, understanding and avoiding discriminatory activities and real estate practices, discovering groups protected under the law, checking out exceptions to the fair housing law, and knowing how to enforce the law. Chapter 5. Knowing the fair housing laws for selling real estate. As a real estate agent, whether broker or salesperson, you're expected to know and abide by fair housing regulations. Real estate agents are players in promoting fair housing and preventing discrimination in housing. State exam writers expect you to know about fair housing laws at the federal level because those laws apply to all parts of the country. Many states, counties, and cities have enacted additional fair housing laws that supplement federal laws. State examiners expect you to know about these local laws. As you study for the state licensing exam, you need to be sure to find out about fair housing laws that apply only to your state or local municipality. In this chapter, I talk about laws the federal governments have adopted to prevent discrimination in the sale and rental of land, houses, and apartments. These federal fair housing laws are a series of separate laws that were enacted at different times. I also talk about groups that are protected by these laws, called protected classes, and the specific discriminatory actions that are forbidden. And to top it all off, I also give you information about how the law is enforced, as well as a few exceptions to the law. Practicing fair housing, the basics. The basic concept and goal for fair housing laws at the federal, state, and local levels is to prevent discrimination in housing and to permit people to have an equal opportunity to live where they want to live. A student of mine once said the only form of discrimination that's legal is monetary. An ad campaign promoting fair housing a while ago stated something to the effect that the only color you can discriminate against is green, as in the color of money. In this section, I discuss specific federal laws that deal with housing discrimination, including some dates that you definitely want to remember. I also expect an interesting case that shows that the law is a law no matter how old it is. In addition, I talk about state and local laws and the all-important fair housing poster. As a broker who hires people, you will also need to be aware of and abide by non-discrimination laws with respect to hiring practices. Generally speaking, equal employment laws aren't taught in real estate courses and are rarely tested. However, if you are a candidate for a broker's license, you need to find out whether your state exam requires you to know anything about equal opportunity employment laws where hiring practices are concerned. Understanding federal fair housing laws. Real estate agents primarily deal with and apply federal housing laws throughout the United States. In this section, I give you information on several federal laws. I can pretty much guarantee that you will see a few of these questions about these laws on the exam. I discuss another set of laws related to the Fair Housing Act in Chapter 15. The chapter is about financing real estate, and the laws I discuss there deal with providing equal opportunity and disclosure in the all-important mortgage loan process. The 1866 Civil Rights Act. In 1866, right after the end of the Civil War, the United States Congress passed the Civil Rights Act in 1866. This law essentially prohibits discrimination in the purchase, sale, lease, or conveyance of real property, real estate and personal property, on the basis of race or color. The language of the act is clear, insofar as it basically says that without any exceptions whatsoever, all citizens shall have the same rights regarding property regardless of race. The other unique thing about this act is that enforcement is accomplished by taking the case directly to the federal court. Although the act itself is important and almost equally important 1968 court case that involves the act resulting in a landmark decision in fair housing laws that you should remember. The case, Jones v. Alfred H. Mayer Company, essentially affirms the fact that the 1866 Act prohibits any discrimination on the basis of race by private individuals and the government with no exceptions. This case was filed shortly after the enactment of the Fair Housing Act of 1968. See the next section. The lack of any exception to the 1866 Act is important because more recent fair housing laws actually include exemptions. Because it is enacted first and still remains on the books, the 1866 Act is deemed valid even today, having even affirmed in the Jones v. Mayer's case as superseding later laws with respect to exemptions regarding discrimination on the basis of race. Because of that, no exception exists with respect to racial discrimination in housing. And for more, see Bending the Rules, Understanding Exceptions to the Law, later in this chapter. The 1968 Fair Housing Act. The Fair Housing Act of 1968 is more technically known as Title 8. Read Title 8 of the Civil Rights Act of 1968. This act, the first in the 20th century, prohibits certain actions that were viewed as discriminatory with respect to housing and specific defined groups called protected classes, to which it applies. Unlike the 1866 Civil Rights Act, see the previous section, it includes specific exemptions. Together with the 1866 Civil Rights Act, the Housing and Community Development Act of 1974, and the Fair Housing Act of 1988, which added even more protected classes to the list. The 1968 Act formed the basis of fair housing standards as they apply to real estate agents throughout the United States. The 1968 Act, enforced by the Department of Housing and Urban Development, HUD. These laws are best understood when they're broken down into what they can do. Prohibited acts. Who you can't do it to, protected classes, and the exceptions to the laws. Presenting them this way enables me to cover with material within its context of what I discuss in the rest of this chapter. Check out Don't Do It, Avoiding Discriminatory Actions, Feeling Safe, Identifying Who's Protected, and Bending the Rules, Understanding the Exceptions to the Law for more details. Research in state and local laws. State and local governments, like counties and cities, have gradually adopted their own fair housing laws. These local laws need to be viewed and obeyed in addition to, and not instead of, the federal laws. The general rules regarding situations in which federal and local laws cover the same issues is that the more restrictive or stricter law applies. Local provisions usually don't add prohibited activities. Federal law is pretty comprehensive with respect to prohibiting discriminatory practices. Local provisions that are sometimes added include additional protected classes or groups that require relief under the fair housing laws. For example, some cities and several states have added sexual orientation as a protected class to their fair housing laws. In addition, exceptions that the federal laws permit sometimes are removed at the local level. For more, see Bending the Rules, Understanding Exceptions to the Law, later in this chapter. Megan's Law is a federal enacted law that prohibits restricting registration of convicted sex offenders after they've released from prison and take up residence in the neighborhood. Megan's Law has raised issues of the civil rights and rights to privacy of offenders in local jurisdictions. So you need to check out your state to determine whether obligation as an agent to provide information to prospective buyers regarding the presence of sex offenders in the neighborhood. For more, see Chapter 4. The exam purposes and, of course, for the purpose of the future real estate practice, you need to research and find out as much as you can about any local, state, and municipal laws that supplement federal fair housing laws. Pay careful attention to any additional prohibited acts, additional protected classes, and exceptions to the exceptions. Displayed in the Fair Housing Poster. The Department of Housing and Urban Development, HUD, which is responsible for the Federal Fair Housing Act, has created a fair housing poster that must be prominently displayed in all real estate offices. Failure to display this sign can be considered noncompliance with fair housing laws and with the use of evidence of discrimination whenever a complaint is brought against a real estate office. HUD also requires that its fair housing logo or any such appropriate wording be used in all real estate advertising. Don't do it. Avoiding discrimination actions. The basis provision of the Fair Housing Act of 1968 defines certain actions that are considered discriminatory and prohibit them. I don't personally know the legislative background that went into writing this into law, but it appears that the Congress was trying to be specific enough to deal with people who may try to split hairs and attempt to circumvent the law that might simply have stated, "Do not discriminate." Specific activities, therefore, are listed in the Fair Housing Act. I discussed and provide examples of each activity that's included. Remember, these actions are considered discriminatory with respect to the housing and are not permitted. For exam purposes, make sure you understand and remember prohibited activities and any identifying them if they are presented in questions. Feature short case studies. For more about groups that are protected, see Feeling Safe, identifying who's protected later in this chapter. No way. Refusing to sell or rent. This prohibited action is easy to pinpoint. Declarations like, "I won't rent you an apartment or sell you my house because you fill blank with a protected class, any race, color, religion, sex, ethnic background, familiar status, or handicap." Of course, a specific reason doesn't have to be mentioned for this kind of refusal to be considered discrimination. On one condition, or a few, changing terms for rental sales and services. A landlord or owner is prohibited from changing the terms or conditions of a real estate or sale of any property for different tenants or buying as a way of discriminating. Here is an example I use in my classes. You own an apartment building and have extensive research damage commonly done by various types of individuals. Developed a detailed schedule for security payments based on race, family status, with children or not, and marital status. Is this activity legal or not? Emphatically not. Even though you supposedly have objective data and probably claim that you're not using this activity to discriminate, but rather only to protect yourself, it nevertheless is viewed as discrimination. You need not apply. Discriminatory advertising. Discriminatory advertising is prohibited. Although discriminatory advertisement is easy to understand, it may be a little confusing to apply. The obvious and outright discriminatory advertisement is, for example, apartment for rent, Latinos not welcome. You'll probably never be able to place such an ad in any reputable newspaper anyway, and even if you could, you'll be breaking the law. Suppose, however, that you place an ad in the suburban newspaper for a few new housing suburb divisions that include a picture of several white families sitting around the backyard barbecue. Such an ad is also considered discriminatory because the ad can be viewed as welcoming only white people to the development. The reverse also would likely be considered discriminatory. For example, an ad showing only Latinos in the background might be viewed as attempting to share the ethnic group to that neighborhood. You can read about sharing later in this chapter. HUD. HUD issued guidelines that must be followed in real estate advertising. These guidelines cover primarily areas possible discrimination. Advertising that use certain words, phrases, pictures, or other visual representations that are discriminatory. Using certain types of media as a means of discrimination. For example, Advertising in media only available to or likely to be seen by targeted groups, protected classes, or even reverse, not seen by those groups, such as a local paper that is read by a white ethnic group. HUD provides familiar, specific information about what language is and isn't acceptable in real estate. Advertising, for exam purposes and for real-world application, remember that the use of certain words or phrases is prohibited, even when the intent is not discriminate. The categories of the prohibited language, with some examples, include the following: code words, catchphrases, or catchphrases. These prohibited words may be a little more subtle and regional in nature. Obvious phrases like integrated neighborhood can't be used. Words like exclusive throughout more subtle may convey a racial, exclusive, or ethnically expensive message and therefore are to be avoided. Color. No one use the word describing color as is related to race or ethnicity is permitted. For example, white or black. Familiar status. The term familiar status generally refers to a person or absence of children in the family. Although material status isn't protected federal class, HUD guidelines prohibit advertising that states or implies married couples only, or whether similar language. Handicap. Property not suitable for a handicapped person, or any language that suggests an exclusive like that is forbidden. Exclusive words like apartment, is handicap accessible or acceptable. National origin. The use of the word that describes national origin like Latino, Mexicans, and so on are prohibited. Race. No use of racial description words such as Asian or Caucasian, for example, is permitted. Religion. Words describing religion like Catholic, Christian, non-Catholic, and so on are prohibited. Sex or gender. The category tends to be problem more with rental housing than housing that's for sale. Any gender preference words are prohibited. For an example is made for the people who want to share an apartment or house with a roommate of the same sex. So you can advertise for a female roommate to share an apartment, but you can't advertise for only a male tenant for a rental apartment in apartment housing you own. In addition, any photo, drawings, or symbols that may imply preference with respect to any of the above categories are prohibited. For example, showing a picture of a church next to the house you're advertising for sale, describing the location by using potential biases references such as near the Catholic Church is prohibited. A reference to a known discriminatory facility must also be avoided. So you won't be advertising a house for sale near the XYZ Community Club when the country club is known for discriminating in its membership policies. Prohibited language, photos, symbols, and so on are considered discriminatory at their face value, or as they appear, meaning the good intentions don't count. Furthermore, discriminatory language can't be used to describe a tenant or buyer's preference, the neighborhood, or the dwelling itself. So good Christian building is just as bad as a prohibited as apartment for rent. Only Christians need apply. Avoid using welcoming and inclusive terms such as advertising that states specific groups are welcome, and the use of HUD fair housing logos and words to the effect that fair housing guidelines apply are the proper way to say that all groups are welcome to buy or rent. One of the factors that HUD addresses in guidelines is the use of the term that have lost the original religious and exclusionary meaning. For example, an ad placed during December that reads, "Give yourself a Christian present with a new house" will not be prohibited. All lies telling someone the property isn't available when it really is. If a house has been sold or an apartment already rented, so be it. But telling someone that an apartment is already rented when it isn't, or the house isn't available for sale when it is, and that's considered discrimination, and therefore is prohibited. This form of discrimination may seem obvious and almost not worthy of its own rule, and although the background of this prohibit has faded into obscurity, I believe it has sometimes to do with the property owner saying that a dwelling unit was unavailable and then defending their actions by indicating that they meant wasn't that the unit was unavailable to a particular person. Scaring people into selling. Blockbustering. Blockbustering generally defines as encouraging people to sell their houses because of an entry or potential entry of a community or neighborhood of a particular group of people. The group usually tends to be different in some aspect, such as race, color, or country of origin. The fear that blockbustering generates is the possible loss of property value, and the idea behind it is to induce panic selling and generate listings of houses to sell or bargains for developers. The prohibition of blockbuster is particularly aimed at members of the real estate industry because these agents benefit from public panic selling into getting new listings. But investors who use blockbustering techniques for profit can also be guilty of discrimination. Telling people where to live. Sharing. Telling people where to live. Steering. Steering is guiding, encouraging, and inducing people to come some way to move to or stay away from a certain area or neighborhood, and it's illegal. Overt steering is easy to understand and avoid. Subtle forms of steering in the name of being helpful, like saying it's a good neighborhood or you wouldn't be happy here, also must be avoided. Participating in what I call self-steering is equally prohibited. What I mean, for example, is that a couple that asks to be shown houses only in white neighborhoods can't be accommodated. You must tell them that you can show them houses that meet their needs and financial situation in various neighborhoods, and then do so. And by the way, although avoiding discrimination is easy when someone says white neighborhoods or understanding like that, it's sometimes a little more difficult to acknowledge the problem when someone asks for a neighborhood where a particular language is heavily spoken because the family just came from this country. Specifically, accommodating a request like this is still considered steering, and it's illegal. Again, you can't show a family a variety of houses that meet their financial space needs and then let them decide. In some states, offering options about the quality of a local school is also considered steering and must be avoided. Though this probably isn't on the exam, real estate agents should provide the same information about a house to every prospective buyer. Providing different information to different buyers, especially when protected classes are involved, could be viewed as discrimination. You can read about protected classes in this section, Feeling Safe, identifying who's protected a little later on. No money for you. Changing loan conditions. Once upon a time, it was a common practice to not lend money to unmarried women unless of their income or employment status. It was common to not count a married woman's income in the mortgage loan calculation because she was likely to quit work to have children. Nowadays, any such actions, including discrimination on the basis of other protected classes such as race or ethnic backgrounds, are forbidden. You can read about laws prohibiting discrimination in mortgage lending in Chapter 15. Put away the crayons. Redlining. Redlining is discrimination in the lending of mortgage money based on location. This happens when the lending institution determines that of various reasons it will no longer make loans in a particular area. It figuratively or literally draws a red line around a particular neighborhood on a map and refuses to make loans on properties in that neighborhood, regardless of the personal income qualifications of the borrower. In 1977, as a result of past redlining activities, the federal government passed the Community Reinvestment Act, which requires certain financial institutions such as banks to develop and implement programs for reinvesting in the neighborhoods through mortgages, home improvements, and other types of loans. These financial institutions came under periodic review to determine whether they're in compliance with the Act. You can join. Denying membership in real estate organization. One of the more blatant forms of exclusionary discrimination is denial of membership in a multiple listing association with certain racial and ethnic groups, because these associations share property listings of houses that are for sale. Such as denial has direct effect on keeping communities segregated. For more on multiple listings, see Chapter 4. A more subtle form of this type of illegal activity is club groups associated with meeting periodically to share property listings that are multiple listing systems don't exist. Denial of membership in such a group is prohibited actions. The prohibition extends to any broker organization that includes personal real estate organizations. Feeling safe. Identify who's protected. Federal fair housing laws protect essentially everyone. The government, however, has created protected classes, groups against which you can't discriminate. There are not so much groups of people as there are characteristics that can be used for the purpose of discrimination, and of course should not be. In this section that follows, I review federal, state, and local protected classes. Knowing the federal protected classes. Since the adoption of the 1968 Fair Housing Act, the history of federal fair housing legislation has been one of extending non-discrimination protections to more and more groups. The following is a summary of legislative actions when they were added, and the classes they protect. And you can expect questions on the state exam about protected classes in which they were added. And when they see questions that are like case studies. 1866 Civil Rights Act protects against racial discrimination. 1968 Federal Fair Housing Act protects race, color, religion, and national origin. 1974 Housing and Communities Development Act protects against sex, gender biases. 1988 Fair Housing Amendment Act protects the handicapped and family statuses present children, takes note of the handicaps include persons with AIDS as well as alcoholics, but not drug addicts, in addition to conditions like visual hearing and physical handicaps and mental disabilities. For more about laws related to the disabled, see Extra Coverage, Protecting the Disabled from Discrimination, later in this chapter. Taken all together, the current federal protected classes are as follows: race, color, religion, national origin, gender, handicap, condition, and familial status. The relative recent addition to the federal protected classes in some instances when the effect falls disproportionately on existing protected class. Criminal history may also fall into categories of a protected class. The guidelines for the class will probably become easier in the coming years, but you should be aware of this change in the law. Recognizing state and local protected classes. Finding out whether the state or local government, countries, towns, villages, or cities within your state have added protected classes to their fair housing laws is one of the most important steps you can take in preparing for the exam. Two or more common classes these days are marital status and sexual orientation. In addition, mental disabilities may be more specifically defined and protected in your state. In addition, local exceptions to the exceptions may have been adopted, meaning that although federal laws may permit an exception, local laws may not. Questions based on state or local fair housing laws are fair game in state real estate exams. And remember that if a local fair housing law and federal fair housing laws are different, the stricter applies. Bending the rules, understanding exceptions to the law. In 1968, Federal Fair Housing Act was written with certain exceptions or cases in which people, in a sense, can discriminate in housing issues. In addition to remembering that exceptions themselves for test purposes, you need to remember that these two important factors with respect to these exceptions. Even if an exception is legal for an individual, such as the owner of a single-family house selling her house, a real estate agent is not permitted to participate in an exception. Real estate agents are held to a higher standard in fair housing matters. Discriminatory advertising may not be used, even when the exception itself is legal. The owner of a single-family home can't use discriminatory advertising in selling her house, even though she could discriminate in the ultimate sale herself. Don't forget that regardless of the exceptions permitted in the 1968 Fair Housing Act, the 1866 Civil Rights Act permits no exceptions with respect to race. The exceptions in the 1988 law are as follows. Age. In order to accommodate age-oriented communities for older adults, an exception is made to the anti-discrimination laws involved in age and familiar presence of children status. Housing may restrict to people 62 years of age or older, or 55 age or older in cases where the least one occupants per unit is 55, and at least 80% of the units are occupied by people ages 55 or older. In these cases, children may be excluded. Owner-occupied housing. Multifamily housing of 2 or 4 units where one of the units is owner-occupied is exempt from fair housing laws. Private clubs. An organization that restricts its members may provide restriction housing to its members, as long as it doesn't offer housing to the general public. Public law occupancy standards. Local maximum occupancy standards are superseding in their application by the Fair Housing Act. For example, if a local law provides a maximum occupancy of 2 people per bathroom, and you rent out a studio apartment in the building you own, you can't be forced to rent the apartment to a couple with a child. Religious organization. Housing sponsored by a religious organization may be restricted to members of a particular religious organization, provided the religion doesn't discriminate in its membership policies. Single-family housing. The sale or rental of a single-family house is exempt from the rules of the Fair Housing Act if the owner doesn't own more than 3 units at one time, and neither a broker nor discriminatory advertising is used. If such property is sold, no more than one house can be sold during every 2 years period. It may happen to you or your grandfather. I want to share a true story with which I in my fair housing classes. Many years ago, my father was a plumber. His shop and many of his customers were located in a typical ethnic neighborhood of first and second generation immigrants. In this case, the immigrants were German. My father, born in the United States, was of German descent. One day, a customer called on him to provide an estimate on some bathroom repairs. The bathroom was old and located in an old 3-unit apartment house. My father encouraged the owner to remodel and upgrade the entire bathroom with a new tub, toilet, sink, vanity, and towel work. Somewhat conspiratory, the customer said that he didn't want to spend the money because the neighborhood was changing. When I was younger, the word changing in context usually meant some lower classes of people, as perceived by the residents, was moving into the neighborhood. My father, knowing the neighborhood quite well, didn't know what the man meant and responded to a quick questioning look. The building owner answered the questioning look by saying, "Italians just brought the house down the block." But that's not the punchline. The Italians who bought the house on the block were an aunt and uncle, specifically an Italian-American mother and sister. And that's a famous radio commentary was used. And the rest of the story I included in the story in the class. I remind my students that discriminatory can be to anyone for any reason, and the facts may have happened to one of their parents or grandparents in the past. Extra coverage, protecting discriminating disabled from discrimination. The disabled are protected as a class with respect to the fair housing laws. Landlords must permit tenants to make reasonable changes to the apartment to accommodate their handicap. Tenants are responsible for renting the apartment to its original condition. However, another law related to the protection of the disabled normally is covered in the test. Congress passed the American with Disabilities Act, the ADA, in 1992 to ensure not only protecting from discrimination, but also to provide access to public spaces. This law, which affects public and commercial buildings, requires buildings to be accessible to handicapped persons. It also requires new multifamily houses of 4 or more units built after March 13, 1991 to be handicap accessible. The rules vary slightly for buildings with and without elevators. Employers, including real estate brokers, must be aware of necessity of their places of employment being accessible to handicapped employees and the handicapped public at large. Real estate agents also need to be aware of the ADA regulations with respect to commercial and other public buildings with which they may be involved. Staying strong, enforcing the law. Complaints regarding violations of the Fair Housing Act must be made to HUD within a year of the event. The HUD conduct an investigation and may attempt to remedy the situation by getting the property owner to violate the law to stop the action and take steps to prevent it from happening again. Those with complaints may also file a suit in a federal court within 2 years of the violation. If HUD finds a property owner guilty following an administrative hearing, it may impose fines up to $10,000 for the first offense, up to $25,000 for the second offense, and it happens within 5 years of the first, up to $50,000 for the third offense. If this happens within 7 years of the first event, in addition, who brings HUD a complaint can sue in federal court, where generally no limits were placed on the monetary damages that can be awarded. Remember that a violation of the 1866 Civil Rights Act prohibits racial discrimination may be brought directly to federal court. Don't forget your state and local laws. State exams writers expect you to know both federal, state, and local laws. Any antitrust discrimination laws that a state passes, as long as it is stricter than the federal law, applies to the situation of the people in the state. Many states have, even the municipalities within the state, have added protected classes. Some states or municipalities have minimized exceptions. In at least one state, a disclosure of rights under the state's human rights laws must be provided to the client or customer, and a poster of the state human rights laws must be displayed in the broker's office. State real estate commissions expect you and real estate agents to obey your state laws regarding so far as to require periodic fair housing education as a condition of license renewal. And that was part 2. So you want to sell real estate, the job and basic laws. Chapter 5, knowing the fair housing laws for selling real estate. Thank you.